little overview of today's presentation. We're going to talk about what probate is and when it's necessary, an overview of the different types of probate administrations, the probate process start to finish. We'll discuss whether some states are better for probate than others, ancillary probate, when probate litigation is necessary, and how to avoid probate, wills, trusts, and entity ownership. First, let's talk about what is estate planning. So estate planning is the managing and passing of your assets through the preparation of documents and retitling of those assets. What I like to do is call it integrated estate planning, because estate planning and asset protection work together to form a comprehensive plan. You have one without the other, it's actually incomplete. Everyone should have an estate plan so that they can control who gets their assets at their death, how and when they get them, and who controls and manages the assets that are passed. Also, the estate plan covers an individual if he or she becomes incapacitated. What's the probate process? Probate is a process used by the court in order to transfer a person's assets at their death. In some states, you call it surrogate's court. In Florida and many other states, we call it probate division in the circuit or civil court. Here we have it in the circuit court. Only assets held individually without a designated payable on death beneficiary would go through probate. That means if you have life insurance and you name adult children as beneficiaries, then your life insurance is not a probatable asset as long as those children are still living at your death. You've got a bank account with a payable on death beneficiary. That also doesn't go through probate. It's important to note that probate cannot be avoided if you simply have a will. Many people are under that misconception, oh, I have a will, I don't have to go through probate. No. If you have a will, then the probatable assets will pass to the people you've designated, but if you don't have a will, you still have probatable assets, and they're going to pass according to whatever the state statute is. So again, just because I have a will doesn't mean I'm not going to go through probate. The difference is who gets to decide where does it actually go. When the assets pass by state law, meaning you don't have a will, that's called intestacy. We've already talked about designated beneficiaries for life insurance, for IRAs, for bank accounts, but there's also something called joint owners with rights of survivorship. So if you have something owned joint with rights of survivorship, that also will pass without probate, because what happens is at your death, the survivor gets the property. Trusts can also avoid probate, but now we're just going to talk about why you want to avoid probate. We'll get into trusts a little bit later. The court process for probate can be very lengthy and very expensive. It also opens up your life to the court. So your will becomes a public document. It's not accessible by everyone depending on the state, but it is in the court record. In addition, who your beneficiaries are, their addresses, what the inventory of the estate is, all that becomes public record. And that means whether it's limited to judges, clerks, family members, and anyone else who finds a way to gain access, it does become something that becomes public record. If you have a trust, that doesn't fall into the category, meaning the trust remains a private document. The probate process involves evaluating your assets and determining the type of administration you're going to need. There's a person who's designated or chooses to be in charge, and that person we call in Florida a personal representative. In other states it's called an executor. That person goes and hires an attorney, files papers with the court, gets appointed as the personal representative or executor, and then what they do is they have to go through all of your stuff so that they get an inventory. And what that means is if they are in charge, they're going through your home, they're going through your drawers, they're going through your papers. They're going to know everything about you because they have to stand in your place in order to present to the judge an inventory of the assets so the assets can be passed either according to your will or according to state statute. The process basically requires, once they're appointed as administrator, they have to wait a minimum period of time for creditors to come forward and make claims against your estate. And then, if all goes well, the assets can be distributed and the estate's closed. Sounds very simple. Yes, it's time-consuming. However, it's not always so simple. Unfortunately, I've rarely seen a case that goes through without issue. The shortest formal estate I've ever done, that's opposed to a summary administration, which I'll explain in a moment, was 5 months from the time it was submitted to the time the single beneficiary with 2 small creditors' claims got their money. The longest ones have been going on for years, even though they have no money in them. But there's always some sort of complication, and it takes time to address them. So the best plan is to actually try to avoid probate. But whether the person has a will or doesn't have a will, if they own individual assets, probate is inevitable, and everyone needs to understand that. And that's why you have to always assume there's a possibility of probate and make sure you do have a will, and you're going to select a personal representative and alternates very carefully, and you're going to keep your papers in good order because remember, somebody is going through them. The more work that needs to be done after your death, the more time it's going to take, the more costly it'll be. And finally, individual assets to pass to beneficiaries who are under 18 are going to require a court guardianship on top of probate. And that'll end when the child reaches 18. So what happens is that if any beneficiary is under 18, that means whether you left them as a beneficiary in your will or you didn't have a will and it goes through what we called intestacy, where it goes by state statute, no, those children cannot take title to any assets. They cannot accept any money. So what happens is someone needs to come forward, usually a parent of the child, and apply to the court for guardianship of the property of the child so that they can essentially take custody to those assets until the child's 18. It's almost the same process as probate in terms of it's expensive, it's not private, and worst is that it ends when the child is 18, which means foreseeably a child in high school who received a large amount of money under a will and had it in a guardianship at 18, they can go to the guardian and go to the court and say, I'll take my money now. Probably not what you would have wanted because I don't know too many responsible 18-year-olds who can handle money. So it's probably better off not to leave money to minors or to make sure if you're doing a will, you make some sort of provision where it goes into a trust, even a simple trust for the minors, or it can be paid to the parent on behalf of the minor. So again, just to repeat the process, somebody gets appointed, whether they're named in your will or they come forward, usually a family member, gets appointed as administrator, they hire an attorney, they file papers with the court, they publish notice to creditors, then they pay the creditors, distribute the assets, and they close the estate. There are several types of probate administrations. The longest and most involved is the formal administration, but there are also short forms. So the first one we have is a disposition of personal property without administration. That's used if there's a spouse or children, and there's basically nothing in the estate that requires a formal administration. So it means there's no real estate. It's only personal property, and it doesn't exceed the cost of the funeral, or it doesn't exceed $6,000 in Florida. So that basically means there's a check lying out there for some refund for something that's under $6,000, something that would basically offset the cost of the funeral. So what happens is that you can actually do this yourself. You really don't need to have an attorney for this. You can go into court. There's like one paper that needs to be filed. You just say what the asset is. You say what the funeral charges were, present a bill, and the court will issue an order that allows the money to be paid out to you, whoever paid that funeral bill. So that's pretty simple. The next type of administration that's less than a formal administration is a summary administration. In Florida, this is basically whatever the probate assets are, less exempt property. So that means not including your homestead real property, a couple of other little things that might be exempt, and it's all under $75,000. Or the person's been dead for 2 years. It's very interesting because if a person's been dead for 3 years and they had $10 million, you can actually still do what's called a summary administration if the types of assets you have don't require an administrator. So that means generally there's either no real estate or the real estate is just going to go to the beneficiaries. They're not going to sell it. Then you can do a summary administration. And it's fairly simple. What you do is you petition the court. You must list all the assets very specifically, their value, and who they're going to go to, including the proportion they're going to go to. And what the judge does is he issues a corresponding order that says exactly the same thing as your petition. And it's basically in and out. You put your petition in, you get back an order. You may or may not choose to file a notice to creditors at that point. If you want to cut off any potential creditors, then you file it, you publish. If you don't, and as the beneficiaries you're willing to take on the liability if a creditor comes forward and you have to give some money back, that's up to you. It's not usually required. Some judges will require it, others will not. I've done it both ways. It just depends on the situation. But that's pretty easy. I've had it done where you can literally go in there and get it done right on the spot. I've had it where it takes, a couple of weeks if the court's backlogged and I send in the papers, but it's not a very difficult process. The only thing you need to know is there are parameters. It has to be no more than $75,000 in the state of Florida that's in probate. Doesn't include anything that didn't go through probate, or the person has to have been gone for more than 2 years. Now we have the formal administration. So the most comprehensive type of administration is the formal administration. This type of probate requires filing of a petition, listing the assets that you know about at the beginning, an approximate value, and the proposed beneficiaries. What happens then is the court appoints a personal representative or executor, depending on which state you're in. They issue letters of administration or letters testamentary. Basically, that gives this person the authority to act on behalf of the deceased. The personal representative then gathers all the information about the decedent's assets, publishes the notice to creditors, and sends the notice to all known creditors. Now, known creditors are anyone who has sent a bill to the household, anyone who has a lawsuit pending against the person who died. Potentially, beneficiaries can also receive a notice to creditors or a notice of not a notice of creditors, but a notice of administration. The idea behind this is you want to cut people's time off to put in any claims against the estate. So the publication, it usually gets 2 consecutive publications in the same newspaper. You can pretty much choose any newspaper in the county that the person died in. And then you send certified mail with a notice to creditors to any known creditor. And anyone who received the certified mail has 30 days from the date that they signed the green card with the certified mail to put in a claim. And any unknown creditors have 90 days from the date of the first publication. So that's why I told you earlier the quickest estate I ever did was 5 months. Because we sent the papers into the court, we got the daughter appointed as personal representative, we published notice to creditors immediately, we sent out 1 or 2 to the known potential creditors, and within 90 days they were cut off, they were done, we knew who claimed, they were valid claims, we sent them checks and distributed out the estate and closed it. If there's a claim that you get that is not something that you think should be paid, then you have to put an objection to the claim. And if you object to the claim, then that creditor either drops it or has to file a lawsuit. So if you think there's some sort of potential objection, you always put in an objection, because then you leave it to the other side to actually file a lawsuit against the estate, which is rare unless it's a really valid claim or, a claim for a high amount. Once the claims period expires, the personal representative calculates the claims, determines if there's enough money in the estate to pay the claims, because sometimes there's not. If there is, then he pays the claims and he starts distributing out to the beneficiaries. Both the creditors who get paid as well as the beneficiaries sign releases before they get the money. And once everything is distributed out, then the personal representative can petition the court to close out the estate and discharge it. Now I want to just tell you advantages and disadvantages of the different types of probate. So there's both advantages and disadvantages to every one of them. But usually you only have one option. So rarely can you say, okay, I want to do a disposition of personal property without administration, unless you qualify for the $6,000 and it's to pay the funeral expenses and there was no real property. So generally no option there. Also, if there's no spouse or child, you can't even do the disposition of personal property without administration. Interestingly enough, the family or the heirs can always choose to do a formal administration no matter what the situation. So even if it's a small estate, they may actually choose to do a formal administration because they may want a personal representative to be appointed so that they can take the position of the decedent. So I've had situations where we could have waited 2 years and then just done a summary administration, but they didn't really want to wait, so they had to do a formal administration. Where there's real property and they want to sell it and they don't want to title to it before they sell it, then we have to sell it in the estate. You're going to need a personal representative appointed for that. The summary administration, as I said, is a much shorter process. It's a much easier process. But if there's a reason for it, you want to do a formal administration. Sometimes people don't want to, get the assets in the summary and have to deal with creditors coming forward later on. So they may choose to do a formal. But I would suggest if you've got real property that nobody wants to take title to, you should always do a formal administration. So does it matter where I probate? Yes, it absolutely does matter. First state you should be probating in is where you live. Where's your domicile? And domicile is where you live with your intent to remain. So if the biggest thing we have in Florida is we have snowbirds and snowflakes. So the snowbirds, they come for the season for a few months. And the snowflakes, they have a place down here and they come back and forth. So I think if you're a snowflake, usually you're not going to put in that 180 days prerequisite to being a Florida domiciliary. But if you're a snowbird, sometimes it's questionable. Now, Florida has some very unique advantages because we don't have a state inheritance tax and we have the Florida homestead. So many people actually want to be Florida residents. So it's a good thing to be domiciled in Florida. But if you are, that's going to be your state where you're going to do your primary probate. And the criteria for that is, do I live here? Was I here more than 180 days in a year? Do I have my car registered here? Do I have my driver's license here? Do I have my voter registration? Is it a Florida will? Those are the things you're looking at to see if somebody is actually domiciled here. Now, once you've done your probate here, if necessary, you also have to evaluate, do I own property outside of the state where I'm living? And that's what we're going to talk about next. Which brings us to ancillary probate. So ancillary probate is where the decedent owns real property in a state other than where he's domiciled. So if I'm a Florida resident and I own a piece of property in Georgia in my name, I'm going to probate potentially in Florida if I have probate assets there, but I'm definitely going to have to file what's called an ancillary probate in the state of Georgia. Now, it can be required sometimes when it's other than real estate. If you have a car registered in another state, they may make you probate that with an ancillary. It's unusual, but it can happen. And what happens is that the ancillary state, which in my example was Georgia, is going to require certain documents from the Florida court. So if you've already done a Florida probate, it's not so difficult. You get a certified copy of the will, potentially of the letters of administration, and things like that, and you repeat the process in another state. That process could be similar to a summary administration, or it could be another formal administration. Again, it's going to depend on what you want to do with the assets and what that individual state requires. One thing you need to be aware of regarding property in other states is that where there's state inheritance taxes, you actually may get taxed from that state even though you don't live there. For instance, if you own property in New York but you're a Florida resident, you're going to get an inheritance tax in New York on the value of the New York property, which is the real estate. So you want to be very careful. You also want to look at if you have to do an ancillary probate but there was no will. Different states have different laws about intestacy. So in Florida, if you've got a spouse, you're survived by a spouse and children, and all those children are the children of that spouse, the spouse gets everything from intestacy. In other states, the spouse would get part and the children would get part. So actually the assets can be distributed differently depending on what state you're probating in. So you always want to make sure, if at all possible, have a will so that everything is consistent. And you need to keep in mind that if you do have property in other states, then it can be additional costs and complications. A will itself will probably be admissible in all states as a foreign will, so that you don't really need to worry about. Let's talk a little bit about probate litigation. Probate litigation comes about generally when a beneficiary contests a will. Now, wills can be contested for undue influence, fraud, mistake, duress, and a bunch of other reasons. Typical would be a will contest involving an illegitimate child who asserts a claim in an estate, or a spouse who wants a larger share. Sometimes it could be a situation where the estate has to sue to claim an asset or to bring a claim for wrongful death on behalf of the estate. Wrongful death is basically where the person who died because of a reason that was not his own fault or was not natural causes. For instance, if there's a car accident that causes the death of someone, the estate would have to sue on their behalf in order to get a recovery for the estate. That will, I tell you, take a lot longer. The estate would have to be open for a long period of time because we all know lawsuits take a very long time to get through unless there's a quick settlement. What happens in that situation is the personal representative becomes the plaintiff. They become the person suing. And vice versa. If the estate is being sued, the personal representative is actually the defendant on behalf of the estate. Probate litigation can take years, can be incredibly costly, and what most people don't even think about, because they don't look at the end result, is that essentially an estate can be bankrupt from having to defend a lawsuit, and then there's nothing left for the beneficiaries. So for that reason, many cases do actually settle. Now, the problem with probate litigation involving a beneficiary asserting a claim or a will contest is there's a lot of emotion involved. Whenever there's emotion involved or there's money, things get ugly. I've personally seen families fight over tiny bits of money as zealously as families who fight over larger fortunes. So in order to avoid litigation, you want to have very well-constructed documents. You want to tell your attorney when they're doing your documents exactly your family situation. You don't want to ever leave out somebody who should have been mentioned, even if you don't want to leave them anything. You don't have to leave them $1, but make sure you mention them and say something like, I've intentionally left no bequest for my son John Doe for reasons known to him or reasons known to me. what you're doing there is you're making sure that it's clear that you didn't forget John Doe. It wasn't an oversight. It wasn't a mistake. There wasn't duress involved in, you're forgetting him. So it's important. I always make sure to, put in the documents if you're not going to leave somebody something and that person would normally inherit from your estate, I would always mention them because I think you create problems by not mentioning them. In terms of what these will contests can be, undue influence. That's where you've got somebody who's in a position to unduly influence the person making the will. Now, mind you, it's not just undue influence. That undue influence has to cause the person making the will to write their will differently than they would have. For instance, I'm living in a condo. I've got a neighbor who takes care of me, spends a lot of time with me, and I leave that neighbor a good portion of my estate. Well, my kids can come in and say, hey, this neighbor unduly influenced my parent. That's why they got a portion of the estate. Now, the children would have to prove that it was undue influence and that it caused the person who wrote the will to write the will differently than they would have. So it's basically the burden is on the children. You've got fraud. Fraud would be where somebody tricked the person into signing a will differently than they would have, or maybe even just tricked them into signing a will, stuck papers under their, big stack of papers and just said, sign here, and the person didn't look. A mistake might be they were under the belief that someone was dead when a child was dead when they wrote the will. Duress. That's when somebody's standing over you and making you do something that you don't want to do. Maybe they have a gun to your head. Maybe they're threatening the life of somebody you know. Maybe they're withholding medication. There's lots of different reasons that people do bring lawsuits. They're not always viable, and as I said earlier, very often they cost the estate so much money that there's really nothing left at the end of it. So how do we avoid probate? Well, you can do a trust. We'll talk about that in a moment. More simply, you can just have bank accounts with beneficiaries or joint owners, retirement accounts with beneficiaries, life insurance, brokerage accounts, all those can have beneficiaries. You can own property with rights of survivorship. What you need to bear in mind, because as I said earlier, we also do asset protection, that anything that you have as joint with somebody else, that means that their creditors can come after your money. So if you have a bank account with $100,000 in it, and you say, okay, I want to add somebody on there so I avoid probate, and I put my son on there with rights of survivorship, if he gets in a car accident and somebody sues him, they can come after that bank account, the whole bank account, because his name's on it. So you want to be very careful about that. Also, anything you leave directly to a beneficiary, well, that'll avoid probate, but then the beneficiary just gets it when you die. That means it doesn't matter if you wanted them to get it all at one time. It doesn't matter if they're going through a divorce. That could be their asset. So you want to keep that in mind, which is what brings us to potentially creating a trust. If you create a trust to hold your assets and it's set up properly and you actually transfer those assets when you're alive, you could theoretically avoid probate for anything that's actually in the trust. And the thing you want to keep in mind is if you don't title for probate avoidance, then it's like you didn't even make the trust. It's called an unfunded trust. So you also want to keep in mind the flexibility if you do create that trust. You can avoid what I just talked about where the beneficiary just gets the property outright in one lump amount. With a trust, you can actually have the trust hold the property for the benefit of the beneficiary and keep it asset protected by using provisions that don't allow the beneficiary to get the money unless the trustee says. So the best thing to do is always to see an attorney who knows how to title your assets to protect them both from creditors and for them to avoid probate. You can also own entities, as we talked about. That's either with a trust, limited liability companies, limited partnerships. Those will actually go through probate unless they're titled in the trust. When should I have my estate plan reviewed? Some people have their estate plan reviewed every few years. Some people never have their estate plan reviewed. The things you should keep in mind is, did you get married? Did you get divorced? Those things absolutely impact your plan. If you have a will before you get married and then you get married and don't change your will, then potentially your spouse can get everything in your estate. If that's not what you wanted, then you need to make sure that you see your attorney after you get married. If you get divorced, your spouse is essentially wiped out of your probate estate, out of your will, out of your trust. They may not be wiped off of contractual things like IRAs and life insurance. So you have to make an active choice to change the beneficiaries there. If you have children, you may want to look at your estate plan. Now, a well-constructed estate plan doesn't need to change if you have additional children. But if you didn't plan for any children in your original plan, then you do want to see your attorney and make sure to make some changes. We talked about earlier about where you're domiciled. So if you change where you live, you change your state, then you definitely want to see an attorney because you want to update those documents and make sure they comply with the state you're in. You may have some advantages to the state you're in, where you can add things in regarding, in Florida we have homestead. We also have a great rule about personal property like jewelry and clothing and artwork, where you can leave it with a separate writing as opposed to changing your will. So you always want to make sure to take advantage of whatever state law you have, and you want to make sure that no other state ever claims you. So you don't want to be the one with the New York will when you've become a Florida resident. And you also want to keep up with what are the changes in the law, because if there are changes in the law that you hear about, well, you want to make sure your documents are up to date. So those are things that you should really think about. Again, the most common is some people, it takes them till they're 50 or 60 before they ever walk into an estate planning attorney's office. But I recommend you don't wait, that if you're old enough to have a will, if you're over 18, make some choices. Actually get a will. And if you really want to avoid probate, then, you should definitely look into getting a trust as well.